My lords, kindly to mention a matter, my lord. My lord,
You have mentioned today is not the main.
there's some urgency. I came yesterday, my lord, because I came without notice, my lord. Now I have served a notice and came back, my lord. My lord, the urgency is that the honorable single bench in a matter has directed me, the University of Health Science, to grant registration to certain students who have not appeared for the qualifying
It was the
examination.
order passed.
My lord, the order was passed on sometime in December, my lord.
You have applied for certificate copy.
My lord, have applied for the certified copy, have got it last week, my lord. And
Then what is the problem? File it.
my lord, we have filed it. My lord, I want to move some precedence to move it urgently because I am facing contempt now.
So it will appear on the next returnable
My
date.
lord, kindly fixes any date, my lord. This
No fixation, it automatically comes.
because
What your file হয়ে থাকে, give the slip.
my lord,
Yes.
Keep the slip.
my lord, Mr. Maiti is assisting me, my lord. He has some personal difficulty on Tuesday, my lord. Can it be on Wednesday or
Wednesday.
obliged, my lord?
Item number 1.
On item number 1, my lord, I appear for the respondent number 1. You may be permitted to join virtually, my lord. So in this matter, Lordship, I have been pleased to put it under to be mentioned because, my lord, the talk of settlement was going on and they were to come up with the modalities, my lord, for whether I can be adopted or accepted in any other school run by the Sevastrom.
Yes. Yes, Mr. Roy, any development?
Yes, so far, my advocate record took instruction from the authority itself, the Shangho, where they said, yes, he was there in the primary section. There is no difficulty on our part to accommodate him in the private section because the secondary section, which he is trying to be accommodated, is that it is only for the girls.
It's only
For the girls' high school.
I see.
There's some, I don't want to say anything more, Maharaj. That was the reason for it.
So now he can join the primary section.
Primary section. He can join, provided this is an only recognition by the primary section. My lord, he has no qualification regarding the training. That will, if you logically record, that is the problem. We might because that it is start. Now we have to qualify all the qualifications mentioned in the for the purpose of a teacher of a primary section. The training subject to question, my lord. The training is subject to question, my lord. Now a primary section required to be.
Lord, I am qualified, really.
He is qualified, well, I don't, because we do not have.
I have the documents.
And what about salary? Salary?
My lord.
Salary?
The salary received by the other teachers.
He was in secondary section.
No, we have the private.
Yes, my lord.
In the primary section. When the girls' school was secondary section, he was directed to take some classes in some of the secondary section. When it was found as a girls' high school, then some counter allegation was that I don't want to say anything, my lord. He was directed to the primary section. He did not come according to him. We have been.
Now, whether he was drawing higher salary or
no.
Salary is not the factor.
Well, I was taking classes and I was appointed in the girls' school, which is the higher secondary one. And the recognition speaks of ROPA.
You join the primary section, which they are asking.
Well, I'll take instruction. This is coming up for the first time with regard to the salary. If they can specify, I will just inform the client. I will come back with the instruction. If they can specify, because I do not have the documents with regard to salary. They claim something.
The salary portion which is followed by the lordship.
On that day regarding salary, some statement.
My lord. That was a specific query from your lordships, with regard to salary.
After my lord was pleased to ask to produce the judgment, which is my lordship's judgment and other judgment, that the majority of it is under the division bench also subject to question, my lord.
That order was challenged in division bench.
Similar manner, that was also referred. My lord's judgment was also referred here regarding the majority of the petition against this. I don't want to place it because it is under the.
Then the problem is solved, Mr. Roy.
Yes, so if that be so, my lord, we have no problem. We have already informed him. We have the letter with us that request him to go back to the primary section.
Where is that letter?
Give that letter.
আমাকে বললো চিঠিটা কোথায়
Later copy recorded it join করে দিতে হবে।
My lord, if your lordship, this is the last salary certificate which is with us.
No, the later.
Later, yes. Right hand corner, your lordship, the signature of the petitioner, respondent is there, Obik Chatterjee. So this is not, my lord Kali concept, this is a school at the remote place, Beldaga. Run by the Shango, now it is get registered without a financial head. Initially, they are
এটা দাও তো।
4,000.
4,000, 5,000, it is not more than that. My lord also consider it that way. It's not a
Keep
registered.
that later, Mr.
Well, with regard to this quantum of salary, my lord, I'd like to join issues, my lord. What they are producing, I do not know, because I have taken out, my lord, the conditions of sanction, which was granted by the board. It specifically says
Mr. Roy says that whatever salary you were enjoying in
My
the
lord.
earlier post,
My
they
lord.
were paying that salary. There is no
Very
problem.
good. My lord, my lord. If that be so, I have nothing to it.
No, we are
If he wants, I can produce a copy to my learned friend for the purpose of perusal, that it is his.
You tell us when can you go and join.
Well, I'll take instruction. Well, kindly passes it over. I will just call my client up and I'll inform this court, my lord. I'll
Even
just call him up and inform.
find out that later for your lordship. Or wait, tomorrow, my lord, I'll produce that later for your lordship also.
You have the letter.
No, it is not. It's fine, my lord.
Because it is informed that he
No,
has
we can do this thing, Mr. Roy. We will record that he will be allowed to join as a teacher in the primary section. This is your submission,
yes.
and we will keep it, and we will ask him to go and join the primary section, and we keep the matter, or we can dispose it of.
That is
today.
why, if I can produce the letter, it will suffice the purpose. He is directed to go and join to the primary section.
Same salary he was drawing.
The salary portion, my lord, it is. I have shown your lordship. If your lordship wants, the other salary certificates are also.
No, we will record that whatever salary he
Yes,
was
yes,
getting,
yes,
he will get.
Yes, there is no problem.
Well, only one. May I be permitted to raise one issue with regard to the pending salary? There was one prayer in the writ petition to which was allowed, my lord, to grant salary for the period he had worked, but he was not paid prior to his forceful removal.
Seriously, he was not there in the school. He did not join.
No.
That is why.
When I had discharged my functions, that was one of the prayers.
About the submission that yes, he can be accommodated, whatever for the lordship, my lord. He did not join. We have the letter and all the documents with us where he was directed to. You can revert back to your original post.
Prior to this,
Used to go there and knowing the girls' school and the allegations were made, we don't want to say anything on that aspect.
I'm not referring to the disputed time period. Prior to that, when I discharged my functions for a specific period, I had not been paid. I'm referring to that period,
Because as
not the disputed period.
he's willing to go back to that private section, we are also not going to take all those things before any court.
Since when he was discontinued?
That means
17.
2017,
20.
where we was initially joined. 2018 onwards, the school was in the girls' school. 2018,
with
he was not there.
But my allegation is October 2017 onwards, the dispute started, my lord.
October 2017.
That has already been
17.
that has been single judge has said that you allow allow him to join and pay the applicable salary to the
Applicable salary, my lord, what the oral civil judge was pleased to opine. The applicable salary
along with area.
ROPA. It is not with
No, ROPA he has not said.
yes, that was the prayer on the basis of which you can logically consider the oral civil judge order.
My prayer was ROPA. That has been recorded.
That has been recorded,
My
but
lord.
court has directed the school to allow applicable salary to the petitioner along with arrears.
my lord.
Period of his absence, as his absence, क्या करना है? টাকাটা দিতে হবে। When you were discontinued,
2018.
My lord, I was never formally discontinued. I was not allowed to enter the premises from October 2017. That is my case.
2017 তো সেটা তো একটা সাবস্টেন্সিয়াল পিরিয়ড।
8 years back.
17 থেকে অনেক সাবস্টেন্সিয়াল পিরিয়ড।
এখানে আমি একটা দেখেছিলাম কোথায় এই যে এইটা কি এই যে 51A page 51A এটা ওদেরই কন্ডিশন
পলিটিক্যালি ডিস্ট্রিক্ট থাকে
আমাদের সাথে
হচ্ছে যেই তুমি অ্যাপিলটা ডিসপোজ করতে হবে।
ওটা ওদের অফার এবং অ্যাকসেপ্ট করলেন কিনা
You, Mr. Roy, you give a letter of appointment in the primary section on the basis and that he will be paid the applicable salary as directed by the learned single judge. You offer that letter to him so that we can keep it on record. He can join, we can dispose of.
My lord.
First, he should join.
Join. So, but the actual salary, my lord, your lordship will find, because society used to write that the par with the salary of the recognized teacher. Some you will logically consider.
No, from 2017 he could not join. So
Not he could not join.
allegedly. Very
Don't
good.
take me as well. It is his allegation has not been joined.
So you finish off the issue when he is
May I submit before lordship subject to my lord's kind approval. I'll bring in the modalities from the authority itself. That from the, you can join what is followed from the lordship, the appointment letter, and indicating the salary portion also to your lordship. So it will not create any further disturbance in the
So,
society.
Mr. Roy, your service, we are not going into
The
ROPA pay
service,
scale.
correct.
We are not going into ROPA pay scale, suppose.
Yes.
But if his non-joining was found to be by the learned single judge that it was illegality on your part from 2017 to 2026, if we go by the order, that is the applicable salary.
That is why if you
So 17 to 26 is a substantial period. And for that, the amount which he was drawing, you pay him that amount.
yes, if the area my lord, then I have to come before your lordship to say that he did not join. It is not the case. He has resisted to join. The honorable signatures are based on the basis of the amendment made that there is no disciplinary proceedings initiated by the authority or the.
All right, you do one thing first, allow him to join and come back and tell us.
Yes, that
Come back and tell us.
what will be the amount?
নিয়ে নাও, ভুলে দাও যে Mr.
Roy, learned advocate appeal
Upon
for the
instruction of
appellant
the
submits that-
otherwise one.
Appeal upon instruction.
submits upon instruction that the petitioner respondent
May join the
may join in the primary section of the school with the same salary which he was drawing previously. I just stopped. Mr. Banerjee, learned advocate, respondent number 1, place for a short
in view there.
and view.
Whatever, Mr. Banerjee, in view
view
there, the respondent petitioner
respondent
shall join the
prospective instruction.
No, join করে আমাদের কাছে আসুক, join. You don't have any problem in joining, and record that.
My lord, May I seek instruction, because this is coming up? I need to seek, but without instruction, if I submit, I will be in a false position. But my lord, I
In view of
তারপরে যেটা লিখছিলে দেখুন মিস্টার
advocate the writ petitioner respondent is directed to take obtain necessary instruction in respect of the such stand taken by the appellate.
কি বলেছো লেখো
take necessary
হ্যাঁ তারপর টেক নেসেসারি ইনস্ট্রাকশন
in respect of such stand taken.
praise for an accommodation to take instruction.
This is praise for an accommodation.
তারপরে তুমি যেটা বলেছো টেক ইনস্ট্রাকশন অ্যাজ টু whether the writ petitioner যে লাইনটা বললি না
Now, I have praise for an accommodation.
না না আগেরটা পড়ো না মিস্টার
And is directed to take or obtain necessary instruction in respect of such stand taken
by the school authority.
In respect of such stand taken by
Even the written instruction from the school also in respect of every matter. So every issues.
So when this is school is where?
At Beldaga.
Belda, Murshidabad.
So very good. This is understood. We have recorded you will
My lord.
instruction, but
Well,
if he agrees to join on the basis of then ask your client to join the post and
My
report
lord,
to us.
my
And
lord.
report to us, Mr. Roy will also be taking instruction as regards your area salaries. And we will keep it on record and dispose it of.
Yeah, that is why
Well.
each issue I'll take written instruction, so it will.
Mr. Roy, this is a very paltry amount, about 4,000 and odd. So ask your school as regards that period if the salary can be paid.
I'll take it, sir.
Just take instruction to them. This is where we are giving you 2 weeks time. In the meantime,
My
if
lord, sure.
we have recorded Mr. Roy's instruction, we have said you are seeking an accommodation to take instruction. However, it
Madam.
is very clear that
My lord.
your client should go
Should
and
join
join.
in the meantime, and
Come back
report.
and tell us. Come back and
Madam.
tell us.
My lord, my lord. I will be persuasive.
actually is the matter for further consideration.
Grateful.
Same heading on
30 আজকে কত তারিখ আজকে
9 তারিখ
9 তারিখ when 29 January
29 January.
Grateful. Grateful, Lord. Deeply obliged.
Grateful, Lordship.
Contempt.
my application for contest. ছেড়ে দিতে পারি জেনে
you are for the petitioner against
union.
oh union
My lord, in this matter, beg to appear for the alleged contempt led by Mr. Kumar Jyoti Tiwari. My lord, I beg to appear online, my lord, because of a medical emergency. I'm led by Mr. Kumar Jyoti Tiwari, my lord.
Actually, they had one party and served. So they are served on this affidavit service. May I file it? The new incumbent. Mr. Vandana
Al-Tadim.
Purani, Secretary Union of India, Minister of Labor and Employment.
what was our where is the order
The order is at page 58. Page 58.
Page 61 is operating person.
pardon
Page 61 is operating person.
Before that, your lordship may kindly come to page 59. The last,
এই কন্টেম্পট অ্যাপ্লিকেশনটা বের করে দাও না
Contempt application টা কোনটা?
এতগুলি কাগজ
হ্যাঁ 24 contempt application টা কোনটা?
এই যে contempt।
এইটা কি? হ্যাঁ এই যে, হ্যাঁ, ঠিক আছে ওকে গসিত করে
but page 58 is short small. I just placed only the lordship page 58 at in the cost title, the last number is IA number CAN 12 of 20 2022. This was one of the petitioners here by the applicant in Can 12 of 2022.
Where you are reading? Where you are reading?
Page 58.
58, yes.
Page 58 the order. But the cost factor at the last also will get page 58. The last number.
Mr. Dotto, please give us 2 minutes time. Let us.
Very good.
Contemplates. Get up there, contemplates. আপনাকে এনগেজ করেছে জিপি কে এনগেজ করেছে জিপি ইজ নট হ্যাঁ ক্যালিবার স্ট্যান্ডিং লাইক জিপি ক্যাটালগ এনগেজ করেছে এটা হলো ফ্যাক্ট
Where is 28th of May 2008?
That is not page. That is page 33. Page 33. Twenty-eighth of May 2008.
You are all retired employees.
That's it.
Now, what is the problem?
Problem is, Malad, in this matter, Malad, that's what I said, Malad, on the order you'll also find.
By the order, we directed extension of the benefits of this memo to the retired employees. Then,
Malad, Malad, the petitioners here were the applicants in
Can 12.
Can
12.
Yes.
I've got a copy of the can. May I hand up to us?
No, tell us what is your grievance.
Here, Malad, there your lordship directed, your lordship has seen the operative part of the order.
Page 61.
Page 61. The applicants, that the third paragraph.
Yes.
Applicants in the application IA Can 12 of 2022 being the retired employees of CBWE cannot also be denied all the benefits as extended in terms of memo dated 28 May 2008. More so when similar relief has been granted in applications filed by other set of retired employees, as would be explicit from the orders dated 7 September 2012 and 17 December 2013. The memo dated 28 May 2008 would also be applicable to the applicants. That is the petitioner's favorable lordship today. And payments should be made by the appropriate authority in their favor in the implementation of the order dated 28 May 2008. That is page 33. That was directed to him. It has not been done. That is why this conflict.
You have not been paid any salary?
No, nothing. Not the benefits. Benefits of this memo dated 28th of May 2008.
What is the benefit exactly?
Benefit lordship can you see? Removal of PRML, may I read for lordship? In compliance, this was in compliance with an order.
So this benefit was given to other retired employees. Then Mr. Tiwari,
give me 4 weeks time, there are some misunderstanding. Misunderstanding in a sense, I'm telling you. Can you have a look? They were under the impression that these benefits should be given to those who are the applicants in the original application. But I had a talk with the secretary today morning. I told her that this is not the case. You misunderstood the order. Can you give me, my lord, 4 weeks time, my lord? I think by this time it will be solved.
They jolly well understood the order. An appeal was.
Yes,
The judgment that was dismissed by the Supreme
Yeah,
Court.
I know that.
Where is that?
That is there. I handed up 2 copies last month.
Yes, SLB you want to dismiss, my lord?
Mr.
They
Tiwari,
couldn't
apply your
understand. They say they couldn't understand
Well,
the.
Mr. Tiwari, apply your good office.
Give me, my lord, 4 weeks time, my lord. I will come back. I think in the meantime it will be solved. Don't record anything. Give me. No, my lord. Kindly
But not.
give me, my lord, 4 weeks time, my lord. Kindly believe me, my lord. I will come back. It will be solved.
After dismissal.
I know that.
I handed up this. May I hand over again?
I am admitting that SLB dismissed.
They say they couldn't understand the text of the order. Everybody has been given this way. Why these people, 17 people have been deprived of their benefits?
সবাই পেয়ে গেছে 56 থেকে আমরা এটা পাইনি আমাদের ডায়েরি নম্বরে
towards complaint.
If your lordship takes up
Mr. Tiwari, we are keeping it on a particular date, recording your contention that you have sought for an accommodation
Yes.
towards compliance, full compliance of this order.
But kindly, my lord, kindly, my lord, just my lord, adjourn it for 4 weeks, my lord. I had a talk with them. My lord, it
You have
will be
no
done.
other alternative.
I have no alternative. No alternative.
In this order, you approach the
No
Supreme
alternative.
Court,
No
Supreme
alternative.
Court
Not
has
only that,
rejected
this
your
benefit has
SLP. Now
no-
we have no other alternative.
no
but to
alternative. I know that no alternative.
So only we can adjourn only on the ground that you are seeking times for compliance of the order.
assurance, matter will be.
My lord, kindly adjourn it for 4 weeks, my lord. It will be done. I am telling you, my lord, don't record anything. It will be done.
It will be done.
It will be done. Don't record anything. It will be done. I am assuring your lordships. I had a talk. My lord, it will be done.
Not 4 weeks, later to a shorter time.
Again, I have to come and
No, we will say that we will only say that your steps are being taken and you want to come back to us with further.
yes.
Towards compliance of the order. And
Out.
towards compliance of
আমার ভাষানো কি আছে আমার আমি
Acha, you listen what we are saying. Evidence of service as file be kept on record.
These 17, they have been
No,
excluded.
we have not recorded.
No, nothing. Very well. It's
Another
not-
he
Recorded
admits-
about that. Since you want the money, na, so
Yes.
they are the superior parties. They are the Union of India,
And we are
and you are
inferior in
poor.
He was a state
You are
government.
poor
inferior in
persons.
bargaining power, inferior in bargaining power.
No. He is appearing for the Almighty Union of India,
Union of
and
India.
your clients are petty employees. But
Petty
the-
employees have
but the
engaged me
vice versa
Mr.
is
Sapon
not
Datta, senior
but the
advocate.
vice versa is not applicable in respect of the
But
appearance.
petty employees have engaged Mr. Sapon Datta, senior advocate. Kindly consider that fact also. Develop.
Because their stomachs are burning.
Yeah.
They are without pay. In these hard days, a person is without pay.
Some benefit, not pay, some benefits.
This is in respect of some benefits.
Yes.
Lordship.
They have
See that it is disbursed in the
I trust Mr. Tiwari, what he says in open court, it will be compliant.
ঠিক আছে
next.
Lordship.
And what about 3, 4, and 5?
No, 3 Mr. Jalsa is appearing on behalf of the
এটা
my lord,
কোথায়?
petitioner.
এটা-
On late.
তিনটা আলাদা থ্রি আলাদা ফোর থেকে ওগুলো রিভিউ করেছে
Yes.
এই রিভিউটা এর সঙ্গে
Mr.
জুড়ে যেতে
Jalsa is appearing on behalf of the petitioner, my lord. He is on leg at court number 18, my lord, seeking a passover, my lord.
Now you are for whom?
4, 5, 6. Not
Then who has preferred the review? Oh,
নো নো
Contempt.
কনস্টেম্প
suppose I'm for
you are
the
for the
petition and the contempt application.
so Ujjwal Rai.
This is number 3.
This is item number 3. I'm not an item number
Oh,
3.
item number
কোনটা দিচ্ছেন এটা কন্টেম্পটের ইয়ে কয় এই
384.
এটা কি ঠিকই আছে
1384.
কন্টেম্পট অ্যাপ্লিকেশনটা কোথায় দেখুন তো এটা ঠিক দিয়েছেন কিনা
It is coming for the second time.
My lord, yes. There was a direction for service, my lord.
Then what happened? You have served.
My lord, I have served, my lord.
Nobody is appearing. When did they get it? When did they get it? তোমার ওই এইটা ট্রান্সফার অফ ইট
ও ডিস্ট্রিক্ট ইন্সপেক্টর স্কুল
8th of December, my lord, 2025.
You were not called for any hearing?
Do not have any instruction, my lord. I believe no, my lord. I was seeking a passover, my lord, and being led by
Passover, how can you get that instruction? You have to talk with your client. Na?
Lord, yes.
Have you done so?
I'm being led by Mr. Ujjwal Rai, my lord. He is leg at court number 8.
Then
Kindly passes it over, my lord.
next.
copy করো other side copy করো
But item number 4, petition and the contempt application. Other petition they are preferred in the
You are the alleged contemner.
not
no.
applicant in the contempt application.
অ্যাপ্লিকেন্ট আস্তে আস্তে ফাইলটা বের করো ওনার সাহেবের কপিটা দাও আমাদের কে সুরজিৎ নেই কে দেখছে ফাইলটা কার্তিক হেল্প করে দাও না একটু। First time it is coming.
No, my lordship, kindly remember, this is a matter wherein your lordship please to direct, my lord, the authorities to fix the, to disburse the notional benefit in favor of the applicant. Now, my lord, we have already disbursed all his retirement benefits. Now, on the last occasion, the applicant raised a point that he is entitled for MACP, which is, my lord, Modified Assured Career Progression Scheme. he is entitled for MSCP, and MSCP was not, the benefit of MSCP was not extended to the applicant. Now, your lordship directed me to take an instruction to consider the scheme and to apprise your lordship whether he is entitled for MSCP or not. Now, my lord, I have come with this scheme, and my lord, it আপনাদের একটা copy. And my lord,
No, what is tell us? Tell us.
as per my understanding, my lord, he is not entitled for MSCP because so far as my lord, the other benefit is concerned, my lord, the and fixation of the notional benefits are concerned, those are, my lord, on the basis of qualified service. And so far as, my lord, the MSCP is concerned, that is, my lord, regular service of 10 years is required. Now, my lord, the applicant completed, my lord, 9 years, 9 months, and 25 days. The basic criteria is, my lord, the 10 years continuous service, which he has not fulfilled. That is the reason, my lord, as
So
per,
thereafter, have you given him pension?
yes, we have pension, the other benefit, all are, my lord, extended to the no. My lord, on the last occasion, we have filed the affidavit stating that all the area benefits, pension, everything was dispersed. Only the question of whether he is entitled for MSCP or not, that point is left open. And my lord, your lordship directed us to take the instruction and go through the scheme whether he is entitled or not. And we have, my lord, come with the scheme to apprise.
Where is the affidavit?
My
You
lord,
have filed affidavit.
yes, yes.
Have you in that did you give the old pension scheme in your affidavit?
My lord, we have that old.
Have you given your reply to that?
No, not today.
Because on the last occasion, my lord, they have submitted that they have they got, my lord, all the benefits excepting MSCP.
To show us where is the direction for MSCP benefit given in the order. Where did we direct that you will get the MSCP benefit?
Last order on 11.
We directed to disbursement of retirement benefits as per the old pension scheme, which they have done. Now, if you are entitled to MSCP, is there any discussion anywhere that MSCP has to be granted to you? Or can you show us that in respect of others who have been treated under old pension scheme have been granted MSCP?
My lord, on that point, I am taking a time because
How much time is required?
I-
He
I
filed the affidavit.
I understood. Devashish,
We are disposing it off, leaving it open for you that if you want any other benefit, you would be.
short time. I'll come up to that. Reply to their affidavit.
This way, matters cannot be kept pending at your will and pleasure.
Because he's in the medical emergency. That's why I appeared. So I didn't appear last occasion.
Who said he did not appear?
No, I didn't appear. So Devashish Sinha was appeared.
Where is he?
It's a medical condition for because he is absent today. He couldn't appear today. Yesterday was.
And so far as, my lord, the MSCP part is concerned,
Just a moment.
But on the,
to his batchmate.
but on the last occasion, Mr. Sinha handed over a letter saying, signed by his client, stating that he has not getting the benefit of MSCP. That is the reason your lordship directed me to take the instruction and go through the scheme whether he is entitled or not.
No,
This is the copy of the letter.
No, Mr. Bhattacharya, why he will not be entitled?
That
Old
is,
pension scheme, new pension scheme does not matter with the
But the-
period of service
Malad,
discharge.
kindly consider the scheme itself. Malad, I have come with the scheme because for the purpose of extending the
Then
benefit.
why didn't you prefer clarification application? Old pension scheme,
Malad, there is,
try to understand, Mr. Bhattacharya. Old pension scheme entitles him to pension.
my lord,
Pension, it is pension. Your MACP is as regards the quantum of service rendered. If he had delivered, he has worked for 9 years, some months. So that deficiency has been directed to be condoned. Once that deficiency is condoned, then he becomes 10 years service. So then why he will not get the MACP?
Yes. The reply is, my lord, for the purpose of the benefit of the pension under the old pension scheme, that is the primary condition is the requirement of qualified service, which your lordship has already been condoned and he has already received the benefits. Now, so far as the MACP is concerned, it required, my lord, the regular service or the actual service, even if...
How much? 10 years?
10 years.
How much service did he render?
9 years, 9 months.
9 years, so 3 months deficiency.
3 month deficiency, and as per the scheme, it is.
No, wait. 3 months deficiency. Then he has rendered 9 years, 9 months. Remaining service has been regularized on notional basis.
My lord.
You have to grant MACP, but taking into consideration that actual benefit for 3 months. Try to appreciate, Mr. Bhattacharya.
My lord, I have gone through the scheme. Lordship, kindly consider the scheme once. If thereafter your lordship so desire, my lord, we are bound.
Prima facie satisfied that you have not complied.
My lord, lordship.
Who is your officer? He is giving his own interpretation.
My lord,
who is your officer? Ask him to appear before.
My lord, my officers are coming regularly, my lord, before your lordship, my lord.
Then
they are coming, my lord. They are, my lord.
Who will pay on court's direction? Your authorities cannot sit in over our decision.
No, absolutely not, my lord.
Yes.
Absolutely not. But
or you show that similarly situated persons have been deprived of that MACP under the old pension scheme.
My lord, that is the reason of what I am trying to satisfy your lordship, that as per the scheme, the seniority or lordship, kindly consider the scheme.
The court directed that you condone the 3 months service. So it was the piecemeal condonation. It is only condonation for notional benefit, not for MACP benefit. Where this interpretation is there?
My lord, kindly consider the scheme once, my lord, for my satisfaction. If your lordship so desire, after considering the scheme that he is also entitled for MACP, my lord, we are bound to, my lord, follow your lordship direction.
I have already said prima facie we are satisfied.
My lord, lordship, and on that day, my lord, we have no occasion to apprise your lordship the scheme. We have today come with the scheme.
What you are showing in old.
My lord, kindly see, my lord. At least, my lord, let us, my lord, try to satisfy your lordship with regard to the scheme. If your lordship, even my lord, finds that he is entitled, my lord, we are bound, my lord. Because, my lord, the basic difference is, my lord.
Which paragraph?
My lord, kindly consider.
This is MACP scheme.
This is the scheme. Kindly consider, my lord, the paragraph 2, my lord, first. Page 1. The government has considered the recommendations of the 6th Pay Commission for introduction of MACPS and has accepted the same with further modification to grant 3 financial upgradation under the MACPS at the intervals of 10, 20, 30 years of continuous regular service. Now, my lord, kindly come to the next page. Page 10. No stepping up of pay in the pay band or grade pay would be admissible with regard to the junior getting more pay than the senior on account of pay fixation under the MACP scheme. Para 10.
Yes, no stepping up of pay in the pay band or grade. Admission to junior. Yes.
Now, my lord. Kindly come to page 6. Paragraph 9. The regular service for the purpose of MACP shall be commenced from the date of joining of a post in direct integrate on a regular basis, either on direct recruitment basis or on absorption stroke re-employment basis. Service rendered on ad hoc contract basis before regular appointment on pre-appointment training shall not be taken into reckoning.
Yes.
So, Malat, here the one of the criteria is that
regular service.
Regular and Malat, it will the date commence from the date of joining on the post.
That is not a problem. Your problem is you are taking a point that 9 years, 9 months he has served. So he has not completed 10 years.
No,
So we will not pay MSCP.
No, my lord,
No, please understand. Once a period of service has been regularized by this court and directing you to grant notional benefits, can you treat that period of 3 months to be irregular service?
my lord, what we require, my lord, we ought to have filed an application for proper, my lord, for explanation or my lord, appropriate order. That is the procedure.
No. This is a stand which you are making out. Your contemners are trying to shift their
My lord,
responsibility.
my lord,
Don't trouble persons like this.
my
Matters
lord,
went
we
up
have,
to SLP.
my lord, kindly appreciate. The case, the dispute of the entire litigation is
Mr. Bhattacharya, you are not satisfied with your answer to this, that condonation of 3 months cannot be treated as regular service. We are sorry, we are not satisfied. No, we will hear it now and we will
another
who is this person who is withholding.
And my lord, another two,
Stop his salary.
my lord, another 2 paragraph I want to just refer, my lord. Paragraph 20. Paragraph 20. Just my lord, only 2 paragraph, my lord, I'm referring, my lord. Financial upgradation under MACPS shall be purely personal to the employee and shall have no relevance to his seniority position. As such, there shall be no additional financial upgradation for the senior employees on the grounds that the junior employees in the grade has got higher grade pay under the MACPS.
What are you saying?
That is not the issue here, junior, senior.
Well, it is kindly consider the letter, which is lastly handed over, my lord. The juniors have been, he have been extended the benefit of MACP and not the petitioner. This is the letter on the last occasion he handed over before
The
your lord.
juniors?
The juniors were extending the benefit of MACP. The juniors who are the same rank of the petitioner, they are extending the benefit, not the petitioner. This is the case before he made up before your lordship. And your lordship was on the is under the observation, my lord, that since your lordship has already extending the notional benefit under the old pension scheme, so my lord, the MACP also we have to extend. And that is the reason your lordship directed me to consider the scheme. And as per my understanding, my lord, what I understand, maybe I am wrong, my lord, that this scheme, my lord, those are, my lord, for the qualified service, and this is, my lord, the regular actual service. That is the reason this scheme, this benefit was not extended. If you,
Mr. Bhattacharya, satisfy us that a period which has been regularized on notional cannot be treated as regular service. You argue that. You argue that. This is nothing but a rigmarole which is being sought to be created by your officers. Once a court has regularized a period, notional benefit, yes, if you take the stand that 10 years MACP benefit is 100 rupees, but since notional benefit was directed for 3 months, we will not pay the entire, but a part of it, calculating how much will be the portion for actual discharge of service of 9 years, 9 months. Suppose it is 100 rupees MACP for 10 years, you can say regular service court has, so we will pay the regular MACP, treating that to be regular service, but actual benefit for those 3 months of MACP cannot be given to you.
my lord, kindly give that observation, my lord. We are, my lord, bound to follow that, my lord. Kindly give that observation, because the difficulty is, my lord, the difficulty is
the calculation.
So we have to interpret our own order.
No, my lord, not your lordships. I'm
Or your misunderstanding.
no, not that, my lord.
So
Not
what
that.
you are showing?
My lord, we are, my lord, following.
Bhattacharya, kindly consider. If a person complete 10 years of service, there is no deficiency of service. Then he will get retirement benefit as well as the benefits of MACP.
Absolutely, my lord.
In the given case, this person was not getting retirement benefit. Why? That there was a deficiency of service of 3 months, shortage of service of 3 months. Now court condoned the 3 months. Now you started interpreting that court condoned for the purpose of granting pensionary benefit, retirement benefit, but not MSP. It is your own interpretation.
Yes.
You are creating confusion. Normally, if a person complete 10 years, he will get, kindly clear your mind. He will get retirement benefit as well as the MSP benefit.
My lord.
Here, he was denied the retirement benefit. Why? There was a shortage of service, of qualifying service for 3 months. Court condoned. You cannot have any authority to sit in appeal over that decision. Now you will treat him to be a employee who has completed 10 years in all respect. Court didn't ask you to give actual benefit, give notional benefit. Then you divided that benefit into 2 parts, one pensionary benefit and an MSP benefit. You says, yes, I shall give pensionary benefit, but I shall not give MSP benefit. Why? Here regular service continues.
That is this particular.
That 3 months has been condoned by the court. You are not in a position to raise any issue to prevent the order being implemented in its letter and spirit. Now, what you are showing, when MSP benefit is given, there must be some dissimilarity. Junior will get more, senior will get less, and hence no stepping up of pay on this ground. Then another, what you are showing in your defense?
Financial upgradation and the.
So financial upgradation, another guy. That means a junior employee, one clerk is getting MSP. Officer has newly joined, he is not getting. So clerk will get benefit for 10 years completion. That financial upgradation, if his pay exceeds the pay of officer, that financial upgradation will be purely personal. The officer tomorrow will not be able to come and say that one clerk is getting more, give me higher pay.
My lord.
And for this cause, why? This person will not get.
And we observed that in your earlier order also. So give the name of your officer, we are going to stop his salary. Who is this person? Who is your disbursing authority?
There are 4 persons, Geeta Singh Rathore, Salil Kumar.
DDO has not been made party, my lord.
And Manish Anand.
DDO is not the authority.
DDO will disburse.
DDO only deploying and disbursing officer.
অন্য জিনিস।
Who is your officer? Who is your superior officer?
The Manish Anand, I think the director HOD.
The drawing and disbursing officer is the responsible, my lord, to decide this.
To disburse all literal benefit. All literal benefits shall include
The retirement benefit subject to correction. The retirement
again you think who complete 10 years.
Yes,
who complete 10 years. An employee who has complete 10 years, he will get retirement benefit as well as MSP benefit.
Yes.
You treat him in all respect that this employee also has completed 10 years. But actually he did not complete and there was a shortage of 3 months. And hence court directed give notional. Court did not direct that give him salary for 3 months.
Yes, that is the observation in paragraph 16 of my lord's judgment.
You give notionally.
That since he has not rendered the actual service, the back wages were denied. That is the observation of my lord in paragraph 16 of the my lord's judgment. So that is the reason, my lord, he has.
Have you seen our earlier order, Mr. Bhattacharya, which we passed in this contempt?
But I remember your lordship directed me to consider the scheme.
Read the order. We have dealt with your argument.
Granted, that should be disbursed. No reason forthcoming how the officers can take the stand that did not complete 10 years surveillance. Just
We have observed that no reason is forthcoming as to how authorities can take a stand that petitioner did not complete 10 years of service and is not entitled to MSCP benefits. So, Mr. Bhattacharya, we are issuing the rule. We are not bound by the interpretation which you will give to this order.
Secretary to issuing authority to DOPP. Secretary কে আছেন তিনি? But I am submitting instead of issue.
Now they will submit that don't ask for issuance of rule against us. Go behind the DDO. See the conduct. See the conduct.
I tell you, Lordship, in
As
this
you
matter, for
submit-
last 4 occasions, for the purpose of disbursement of pension, basically, these officers who are situated in Calcutta, they are, their hands are simply empty.
We will record that and issue rule against the contemptor number 1. We will record your officer stand that we are not responsible. Get hold of the respondent number 1, who is the Chief Executive Officer, Director General of National. We are asking him to be personally present. Then they will feel the pinch. Otherwise, they will not. You cannot now avoid your responsibility.
কোর্ট তো অর্ডার দিয়েছে, কতবার অর্ডার দেবে আপনাকে? What I am praying, kindly give me a fortnight time, so that I can let them understand what would be the consequence.
They understand more than you, Mr. Bhattacharya, subject to correction. When it speaks about money, they understand more than you. Nobody will take responsibility. Oh, go to that officer. Oh, I am not that officer. Go to that officer. Oh, no, I am not that officer. Don't catch me. This is their conduct and attitude.
And everybody forgetting that he is going to retire after some days. Once a day.
That nobody remembers, Mr. Bhattacharya.
Can you give, I try to make them understand what would be the consequence. Even if they stick on their stand, issue the rule on whatever order your lordship desire to pass on the next day.
You explain them that if they do not disperse that MSCP, in the meantime, we are issuing rule.
Lordship. MSCP কি উনি পাবেন না? What I have been instructed that for the purpose of issuing MSCP, meanwhile, it will take refixation of the entire thing which has been uploaded in the Bhavishya portal.
Do whatever you can. That is not our headache. What Bhavishya portal or Unbhavishya portal, that is your business.
Kindly give us fortnight time, so that we are trying to. ওটা অলরেডি আগের দিনের অর্ডারে লেখা আছে।
Records would reveal that when the matter was last taken up for hearing on 28 November
But my review is also pending. Review is pending.
If you do not comply, we will on that date we will consider your review and pass appropriate order.
ও তাহলে ওর বোধহয় নামটা লেখাতে হবে নাকি?
ওটা তো ফার্স্ট টাইটেলে আছে মনে হয়।
Same writ petition.
Who are you?
The same department, same department.
The review application has been filed.
Yes. I have been mentioned.
What is that you are searching?
This is next matter.
No, very good. Your review application.
Oh.
Review application. We have told Mr. Bhattacharya, he will take necessary. If he does not comply, we will take up the review and consider. Before issuance of rule, we have to remove that obstacle. Otherwise, no. But it is on his request we are doing. Yes, next.
I am for the petition.
We are filing affidavit of
After number?
seven.
Oh, 7.
Amitabh.
Oh. Copy দিবেন না?
Huh? তুমি দাওনি কপি?
Review formally file করে রেখে।
ওরা রেকর্ড করাতে চাইছে সেইটাই।
আগের অর্ডার দেখো না, আগের and
Because in this case, my lord, there is, unlike the previous case, it is only matter of delay, my lord, in accounting.
no, we will.
Nothing has been held back.
Documents, my lord. So kindly see this document.
No, he says that we have some amount of consequential benefit has not been paid.
Consequential benefits, my lord. That has to be calculated.
Chances of promotion, future promotion.
That is also
Because
there.
it's a seniority matter, my lord. My lord directed the seniority.
That
That
is-
they have been this department wrote to the letter to the board, OFB board, Ordnance Factory Board, to for further compliance. My lord. They have not, my lord, till date they have not issued any.
That specifically
part
will
is
say the
gonna-
problem we are facing. This was previously under the Ordnance Factory Board. Now they have been broken up into companies.
You are for all the containers,
All
Mr.
the
Dasgupta.
The page 6, he has been given promotion. The order to part directed to grant notional promotion and then consequential benefit of that promotion. Page 6, actual date of CMT such and such notional date. Mr. Chatterjee.
Yes, 6.
Seniority and
Check.
frictional benefits.
Yes, my lord. That I have received. This copy I have received.
That means you have given notional promotion.
But there is
But not
another-
consequential benefit has not been given as yet. It is under process.
No, from the date Tapos was given.
But see, if the Tapos was given, my lord, if there is a, this is a case, there is a future promotion is there. Tapos is got some promotion. That promotion I have to, notionally I have to. They are
They are also considering, they have stated
They have to consider.
in
That is
para
what I have
6,
to hand it
There
over.
are 6.
in para 6, they are considering whether you will get further promotion or not,
Yes, yes,
as consequential benefit of that promotion.
yes, yes, yes.
So they are ceasing over the matter.
2 weeks time may be given, I will file an
No,
exception.
you file an exception. We keep it on 6th. In the meantime, it is complied.
I will
Otherwise,
withdraw the control, all my disclosure.
Mr. Dasgupta, learned advocate, appearing for the
Lordship, I'm for the contempt led by Mr. Galib, Lordship. Lordship, in the morning today only we have received the engagement. I have nothing with me, Lordship.
But
In the morning only we have got the engagement, Lordship. So the contempt copy or anything is not with me, Lordship. I'm praying for 2 days.
so we will ask your officer to come.
Lordship, kindly, Lordship, 2-week accommodation we will arrange.
What order did we pass?
Orders is at page 19 and the operating part is at page 29.
Yes, please.
Oh,
Accordingly, the order of termination dated 30th June 2023 issued by the ADPIG Correctional Home Services. The order passed by the self-same officer on 13th June 2023, which was communicated to the petitioner by memo number 7 July 2023 and the impugned order of Learned Tribunal dated 16 May 2024 are satisfied, and the respondent are directed to allow the petitioner to join the post of DGO at Baripur CCH and to disburse all consequential benefit in his favor within a period of 4 weeks from the date of communication of this order. Pursuant to your lordship's order, I am allowed to join. Now, kindly come to page 33.
33.
But AIG headquarter by a memo dated 20th.
Your page initial is not given in the contempt application. Eh.
no pagination.
Listening.
So you have been allowed to join, but they have not disbursed the consequential benefit.
Yes, but consequence by a letter dated 20th April 2025, the consequential benefit was calculated.
Where is that?
Statement showing area.
20th
April 2025. Kindly allow me to present. I will take this. Yes, well, that 20th. This was sent by the AIG headquarter to the principal secretary for disbursement, but till today nothing has been done.
17 January 2025, you have been
Allowed to join.
allowed to join. You are drawing current salary.
I'm doing current.
এরিয়া স্যালারিটা দেয়নি।
আসো এফিডেভিট অফ সার্ভিস কমাস
Lordship, Shamimul Bari is appearing on behalf of the appellant, Lordship, praying for not today, Lordship.
I'm for the read petitioner respondent. My Lord, Mr. Bisharu Bishas is coming, my Lord.
Pardon?
Mr. Bisharu Bishas is coming, my Lord. My Lord, last occasion, my
What
Lord.
are the two applications?
My Lord, last occasion, my Lord, so please to file the objection against the section 5. That was given, but no reply has been given.
He's engaged in courtroom number 18, Lordship.
The
Kindly.
contempt matter is pending. After 8th month, my Lord, appeal has been filed.
Proceed in contempt. Proceed in contempt.
No,
How many days delay?
My Lord, delay is, my Lord.
216 days.
No explanation has been given in the paragraph 8. 11/4/2025 to 2/7/2025. Well, I have taken my para 4 for my objection. No, my senior is coming, my lord. Pass over, my lord.
Yes, next.
Not today.
Not today করুন না স্যার আমরা আবার এসে বলবে আমায় টাইম দাও রিপ্লাইটা ফাইল 19th January 20th January করে দাও you file the reply in the meantime yes next
But this matter pertains to the extension of validity of recommendation. This similar upper primary extension of validity of recommendation, that 90 days, 150 days. Your lordships have been considering this issue.
Mr. Ghosh Chaudhary's matter, your lordship is considering, and that those 4 matters have been posted probably on 17th of this month. So kindly, this matter may be posted on 17th or any day thereafter, my lord.
Very well.
So that, my lord,
17th is a Saturday.
my lord, then 16th, my lord, posted on 16th. My lord, kindly fix the matter on 19th.
16th it has been posted.
কবে আছে সুদীপ দা তোমার এই matter গুলো? 2 week 16th, my lord.
16th
2 weeks after.
which is your matter which এটা নোট করে নাও
সাহেব কারো
but which is your matter
thereafter
19
হতে পারে
16 তারিখে দেখো
16 জানুয়ারি আছে
27 জানুয়ারি রেখে দিই
বলো নাম্বারটা বলো না
Last matter is at 1542.
What is the matter about?
This is the extension of validity period of recommendation that after 90 days, within 150 days, I applied. So
they have got recommendation.
There is a provision at Rule 17 that the commission, even after 90 days, there is a window for the applicant to be considered by the commission. So in my case, that was not allowed to me. So that is why I have.
No, his case was that 90 days was over. No?
Yes, my case is also 90 days over, but within 150 days.
In my case, my lord, commission has already extended. Now it is ready for dismissal.
আচ্ছা তাহলে ওই
Along with this
ওই
matter-
ম্যাটারটা ওই যে নাম্বারটা নিয়েছো
19 তারিখে করো
পারবে
না
খেয়াল রাখতে
19 তারিখে
2 weeks আচ্ছা
19th, my lord.
my lord, kindly fix all those matter on 19th, my lord.
19th it won't be possible
Because, my lord,
30th January
30th January, my lord.
30th January. Very well.
yes next
এই ম্যাটারটাও হবে 30th.
30th না 30th is a Friday keep it on 3rd February
Great.
3rd February. Great.
yes next
This matter also 3rd
হ্যাঁ
February.
একসঙ্গে
এই আমার লিস্টটা নিয়ে চলে গেছে নাকি
right
same matter
no, my lord.
11
will time for that. Hey, more.
You know.
But this matter pertains to mutual transfer order of teachers.
oh একটা
The order impugned on 22nd September 2025. Matter pertains to matters mutual transfer with respect of
delay section 5.
yes, I have given. Section 5 is there. 26 days. 26 days.
So where is the order impugned?
Yes, my lord, in MAT. Yes, my lord. In memo of appeal,
Why don't you annex it in the step?
Yes. Yes, my lord, it has been stated in May. Yes.
2 pages order, you cannot Xerox and place it. Instead delayed by 26. Where is your delay application?
Lord, I have filed.
Upon hearing the learned
in online format, when offline application was, offline system was initiated, that application is required. Subsequently, my lord, in Utsosri, online platform has started. In online platform, there is a unique number in my code. When I applied in the portal within my profile open, and if naturally, my lord, partners profile unique number, partners profile open. If my lord both offer and accepted, it has offer and accepted. If the matching, the mutual transfer, that must be in same pattern. If their profile is matching, it has been matched, and straight away go to the commission. Commission is to consider it. This is the provision. In offline pattern, there is a specification in the rule. In offline form is to be filled up. In 1,000 rupees draft to be included. NOC is given by the.
What happened?
My lord, my transfer application is pending before the commission. Let my learned friend assured that I have made a defective application. That is my case.
So
I made
offline
online application. There is no such provision in NOC part. There is no such provision to take NOC.
That's no objection.
No objection.
There is no
provision in online. I have clearly, it is not defective application. It is properly applied in the portal. It has been forwarded to the commission. Now authority is to consider.
My lord, I cannot go beyond my own law, my lord. My lord, only rules which are framed for mutual transfer is 2012. Now, thereafter, no law has been amended, my lord. Law has not been amended till today, my lord. Since law provides, then NOC is required for mutual transfer. My lord, I have to, my lord, take NOC, my lord. The aspiring candidate has to take no objection certificate from the concerned school authority. Otherwise, if any disciplinary proceedings is pending against him or her, how the commission will realize that certain proceedings are pending? He will.
Where is that provision?
Yes. Well, rule 4, my lord, kindly see rule 4.2.
Yes.
Rule 4.2, I have given, my lord. The applications so submitted that contain the NOC, no objection and declaration of the school managing school mentioned as part 2 of the form. Under the signature and seal of the secretary, managing committee of the administrator of the school and the headmaster, headmistress in charge, as the case may be.
So why you are saying this is required when it is offline?
Offline.
But how do you show that?
My lord, online rule, my learned friend also admitted that rule has not amended.
Suppose online that column was not there.
Not there.
So, but without no objection, this way or that way, you cannot be considered.
No, my lord, this, my lord, they generally, my lord, they are
Why your school is not giving you no objection?
definitely, my lord. I have
It's your problem, sir.
my lord, where I shall included it.
We will include now.
Yes.
Include
Give the no objection, we will dispose it.
My lord,
No,
kindly
very
direct,
good, my lord.
the School Service Commission to give a hearing and kindly direct them to produce the no objection certificate at the time of hearing.
My prayer. That is my prayer. I have no problem. And school is saying if not, you know,
Agent,
Lord, may I take your lordship's leave?
Word for whom?
Perhaps
কেন তুমি তো ওর ভিউটাই আপলোড করছো।
Item 12, my lord, I am appearing for the respondent number 2, Paschim Bongo Samogra Shiksha Mission.
My lord, I am for the state respondent. My lord, I tendered my apology. There is a direction to file exchange of affidavit. My lord, I am in default. I pray
You have not filed.
extension of 10 days.
What is the matter about?
On a matter, my lord, relating to appointment in the post of para teacher.
Achha.
Advertisement was there, my lord, in the year 2007, 4. There was an advertisement thereby inviting applications from the concern of individuals for the post of geography and other teachers. I am for the geography post. I duly appeared. Subsequently, my lord, panel has been prepared. The expert of that panel certified that I stood first in the said panel in respect of geography subject. But I was denied the appointment, saying that subsequently the advertisement was changed in the English version. Initially, the advertisement was made in Bengali version. They are taking the plea that subsequently the next advertisement was made in the English version, so there was no post for geography. But expert is saying, by way of giving certificate, the interview was held and he was expert in the geography teacher. An interview he took and the particular this petitioner stood first. So
for whom you are appearing?
No, my lord, I am appearing for the project officer, who is, my lord, at the relevant point of time was the officer who approves the panel. The appointing authority was the school. Now,
expert, who was the expert? Means school appointed expert.
Yes. Now the school, my lord, sent the documents. We found that all these posts, my lord, were earmarked for women candidates. Therefore, my lord, the DPO, my lord, submitted a report before the learned single judge saying that whatever records we found from the school, being the appointing authority, we found all those posts were earmarked for women candidates. Women candidates were selected, panels were produced, incorporating the names of 6 female candidates, and based on that, my lord, appointment were given. After a lapse of 3.5 years,
they school forwarded to you
all female candidates name.
All
female candidates name, and question of, my lord, giving an opportunity to the petitioner being the male candidate does not and cannot arise.
That is specified in the
advertisement. Yes, report was filed by the DPO, and my lord, based on that, my lord, 2 female candidates were appointed. Then after a lapse of 3.5 years, a writ petition was filed. Before that, a suit was filed. Then a writ petition was filed. Now it was taken up, my lord, on 1st of May 2024, and by the impugned judgment, my lord, the learned single judge, my lord, was pleased to observe that all these issues involved in this writ petitions are disputed question of fact. In a writ jurisdiction, my lord, how can this issue be decided? That is why, my lord, writ petition was dismissed.
What is the disputed question?
Disputed question,
for you women. Then what?
Yes. But, my lord, for redressal of his grievances, my lord, the learned single judge said you may approach the civil court if, my lord, the school produce other records or. But the issue is, my lord, settled. All these issues are settled, and this application, my lord, your lordship will find this suffers from non-joinder of necessary parties because the selected female candidates were not made parties.
Probably my language has not been properly instructed. But the advertisement will speak itself, my lord, that the post was not reserved for any female candidate. 50% post advertised, the 7 posts were there. 50% posts are reserved for female. But now they are saying that taking the plea that all the posts are reserved for female.
Can you file?
It is not correct.
2 weeks.
Mr. Das, learned advocate, appearing for the state respondent.
Writing number 13, I've been informed that the advocate on record could not come to court since his mother is not well. I'm only praying for a not to delay.
My lord, there is a direction for us to file a report in a sealed cover.
ফাইলটা দাও। What is the matter, Mr. Das?
He's a organizing teacher. My lord, he prays for an indication. My lord, 100 single judge has dismissed his application, but with a prayer, he has to file an application afresh before the authority, before the board. The only moot question is that the applicability of the rules at the material point of time. What is the rules? Or Supreme Court has given at an appropriate stage. An appropriate stage means if he comes, his fresh application be considered at
judgmental জন্য four
district inspector of school.
এক্ষুনি খুলো না না। আর where is the secretary's report?
Report filed by the on behalf of
district inspector of schools,
on
state
the district inspector of schools as well as on behalf of
West Bengal Board of Secondary Education.
Secretary of the West Bengal Board of Secondary Education in terms of the order dated 10/11/2025 are taken on record. Stop.
Service done?
Service done. Section 5. Section 5 application.
How many days?
480. 480, no? 484. But in similar matter, the Lordship has three matters, 3 or 2 matters. But your Lordship has been teach to stay the order impugned.
We stayed the order impugned.
Yes. But so far as this matter is concerned, Lord, this matter not filed in time. That's why I'm not 480 days delay.
Now, whose appeal we stayed the order?
State appeal against the order. If your Lordship kindly see the order.
Oh, then the writ petition was separate writ petitions?
Separate writ petitions. Appeal against appeal, your Lordship heard and then stay.
No, against the said impugned order.
No. Not against similar matters. Similar matters. Not this matter. Right? Not this matter, but similar matters.
You have exchanged your affidavits?
No, because they have
Section 5.
Section 5 is there.
Yes.
Section 5 there. Section 5 opposition is there. They have filed the opposition. There, what is the stand? আমরা opposition দিই। হ্যাঁ, section 5 দিয়েছো দেখো। Opposition তোমরা দিয়েছো। হ্যাঁ, সেটাই দেখো। আমরা দিয়েছি, তুমি section 5 এর রিপ্লাই দিয়েছো একটা।
Then similar matter, what is the similar matter?
If your Lordship kindly see your Lordship's earlier orders and kindly see the order impugned in the appeal. Because earlier question your lordship pleasure was the section 5 I will matter will taken first,
Then
then
relating to compassionate appointment, if your lordship kindly see the present appeal at page 61.
Then whatever Supreme Court order give এগুলো হচ্ছে ওই ইয়ের ব্যাপারে
Supreme Court's order, Lord, I have brought the order.
স্টে করে দিয়েছে ওই দিস ইজ দি ইস্যু whether college can consider
But I take your lordship's view.
whether
But
college
the issue involved merit on merit, whether the Calcutta University statute contains a clause for compassionate appointment or not. That is the larger issue. Now the state has filed against that order series of order, but in one of the matter, the contempt proceeding was stayed. Other matters,
two matters.
One or two matters, contempt
Matters
proceedings
stayed.
was stayed by the Honorable Supreme
Order-
Court.
order
Now the state is not pursuing for the final disposal of the appeal SLP. Now, before going into the merit of this matter, your lordship, last occasion, we placed the section 5 application, your lordship was pleased to decide the section 5 application because there is no sufficient explanation in the application itself. So, section 5 application, your lordship was pleasure to decide this on the strength of this the contentions and there is sufficient explanation in the section 5 application or not. Because there is 330
even if we dismiss the section 5 still it will not be considered no
but the problem
the
is
state appeal also cannot also proceed because Supreme Court is insisting.
Supreme Court in another matter is state but contempt proceedings not is the court can proceed unless this particular issue is
It's a broader issue na it's a broader issue
broader
now.
issue, but this unfortunate state of affairs, the 13 years not back, we have been serving from 2006 onwards. The state is not pursuing the appeal. There's no progress in the SLP. No endeavor made by
Take steps you take steps
but I am not the party here. There another case. It's only my case here. We have one before the not the or single bench, single bench, not a single judge, not only directed to make an inquiry. So no prejudice will be caused to the state. To make an inquiry, if I am found suitable, then my case will be recommended. It's not direct the order for appointment, giving appointment. So what is the prejudice caused to the state to make an inquiry?
Unless there is a scheme, how can we dilute?
My learned friend is saying, the relevant college can cause an inquiry to ascertain whether if the inquiry report justifies the compassionate appointment in favor of the petitioner, college shall recommended the petitioner's name for compassionate appointment.
thrashed out. So
Yes,
we
to
are
be thrashed out.
condoning the delay, and for a limited period, we are saying not. You have filed contempt.
Yes, contempt proceeding. The Learned Singh judge
Then
is
you
not.
do not proceed with the contempt in the meantime for a limited period.
But only difficult is that I was my case is I have applied in 2000, serving in the skill from 2006. Ultimately, the state will say the time has elapsed, so the case of compensation amendment goes. That's not unfortunate
That
thing.
case has already 13 years you have.
I have been serving.
And when did the death occur?
Not by that.
When did your relative expire?
Death is not on 2000.
2000.
I have
6
been
years
serving.
gone.
I have been serving in the school. My case was recommended by the school authority. Ultimately, approval was not given. So
that is because the scheme is not available. That is their
the
ground.
scheme is there at on merit, on merit, not on merit,
On merit.
on merit. Your lordship, not if your lordship, not
You file your opposition to the
main
stay
application.
application.
Yes,
And we are
your lordship decides this issue.
we will decide. We will take into consideration that state has not taken steps in
Yes,
SLP.
yes, yes. Your lordship decides that. I will satisfy your lordship that the scheme is definitely there. Because division bench's order is in my favor. All division bench's order.
আচ্ছা, can 1 of 2025 stop. This is an application for condonation of delay. Stop. Upon hearing the
Lordship, I have received opposition reply. I'm paying 1 week time to file reply.
But there is a direction of filing my lord, review to opposition and reply. Today I am filing my opposition.
Mr. Learned Advocate appearing for the respondent.
My respectful submission,
And for the state, while I'm praying for a day's accommodation,
my lord, 3 times already they have taken time for filing affidavit of
Mr.
opposition.
Joydeep Banerjee is appearing in this matter. I have been instructed over telephone to take an adjournment today.
No, if the advocate sleep at home, we have to adjourn.
And I have just been informed.
Can this be a ground, madam? Tell us.
Definitely not.
Friday there will be 3:30. I will not go from the court. If this is the work culture, then what will happen to our institution?
3 times already.
Unfortunate state of affairs. Very unfortunate. So, देखिए file ta the. What is the main matter about?
Main matter is the appointment, approval of appointment. Subject first, main matter. Thereafter, your authority concerned.
Now opposition filed.
My lord.
Have they filed their opposition?
No, my lord. 6 times lead petitions
Did
were
you intimate the respondent number 5?
My lord.
Did you intimate the respondent number 5?
Lordship, I have affidavit of service I have already filed, my lord.
On 15 September, we said that you intimate the order to the respondent number 5 also.
Lordship,
school.
I have served an affidavit of service was filed before the court, my lord. So, school authority knowing fully, ignoring the order of the honorable court. May I press the
How can you get service, Mr. Vandal? Regularization of service.
Lordship. My first prayer, my lord, my prayer before your lordship, the authority concerned issued an order that his appointment letter is fake. This is my humble and respectful submission before lordship. Your lordship, can you see for a moment, your lordship? I want to place one after another the order of the.
What will you place? Which is the law which allows you regularization today? Have you brought any judgments? Assuming that you are in service, you have worked, you are not allowed.
Already retired.
Then what remains? You have already retired also.
Lordship.
Then what benefit you will get here?
My lord, this is my second prayer, my lord. First prayer is
Tell us, regularization.
Before that, only my prayer. They told me that my appointment letter is fake. That is why this is my first prayer. Before going to die, he should not get a black report in his favor.
This order is under challenge before us.
My lord.
This order passed in the petition is under challenge before us. You come to page the internal page 3. On 3 counts, your prayer for regularization has been rejected.
Lordship.
What is the 3 counts? That there was no prior permission,
Lordship,
to appoint you. On second counts, that there is no panel, 3-month panel is required to be prepared after completion of the selection process. Thereafter, the same is required to be sent to the DI, seeking his approval. Then lastly, you have not been able to show that your appointment was done in following the recruitment rules. So you show us these 3 observations are wrong.
In this regard, my respectful submission, one after another, I am placing. Your lordship can see this stay application, my lord. In the year 1991, 3rd January, the petitioner was appointed.
Whether prior permission was there?
No, there was no prior permission. But at that point of time,
forget about whether 3-man panel was prepared.
No, my lord. My lord, at that point of time.
Again, no. Whether appointment was made following the regular recruitment process, extent applicable at that time.
Well, in this regard, my respectful time at that point of time, they were for pressure of the students, the school authority appointed one clerk. Same and identical nature of fact. The another school already engaged the petitioner by the order of the Honorable Court, and he is getting the pension benefits which I have annexed in my petition. It is my humble 1991. At that point of time, Your Lordship, for a moment, in this regard, I am placing the said two orders, my Lord. Your Lordship, for a moment, my Lord. Page number 290, as well as
how we shall come out from this question raised and specific observation made by the single judge.
My Lord, in this regard, at that point of time, so many schools appointed the teachers as well as the clerk, and subsequently they were absorbed. And that is why I am placing page number 289 for a moment, my Lord.
In law, there is a
that I know, my Lord.
Proposition.
I know everything.
You cannot claim the negative equality.
I am
If
claiming
in any school, any appointment is made without following the recruitment rules, you cannot claim that benefit. That my appointment should also be regularized and benefit is to be given.
In this regard, I am placing
that would be claiming of negative equality.
In this regard, you will also going to see for a moment page number 289, my Lord, in my stay application. For my satisfaction, my Lord. So this was the system, my Lord. Not only that, my appointment letter is not fake, and I am producing this documents.
That point has not
Reply
been.
you have filed.
No one.
Opposition you have not filed.
My senior Mr. Jodip Banerjee is not read.
Yes. He's at home.
He has not come to the court, my lord.
Had Mr. Bhandari, learned advocate, appearing for the appellant?
The next item, I'm for the appellant.
I'm for the state.
Other side, Malad, the Poddut Kumar Das, he personally problem, Malad, he could not come to court. Malad requested me to not to do this today. So Malad only make it not today. We will do Malad also.
That higher pay scale?
Higher pay scale, there is order for to take instruction. He has taken instruction. Malad, what on just so Malad not to. Lord, item.
I'm praying for adjournment.
Yes.
Malad, only not to do.
You are there?
No, I mean 18, my lord, before recess, lordship will assemble. Before recess.
No, after recess we will come.
My lord, item number 20, my lord, kindly.
Wait for your chance.
Not today, mark karo, no, our
Item number
17.
17 টা ডাকো এটাকে 29th January come back on that.
17. Item number 17.
একটা কপি দিয়ে দে আমাকে
But in 18 and 19, I am appearing for the respondent number 6, the school authority. My lord, may I file my affidavit in opposition?
Is for the appellate.
Lord, I appear for the appellant. But I have been handed over. This was affirmed on the 10th of December.
Served also.
It was served also. Unfortunately, it didn't reach me. Extra copy has been given to me. I was seeking an extension of time to use a reply, my lord.
এই নিয়ে নাও।
এইটা একটু দুটো ম্যাম 18
recorded it here.
18 in opposition
Like
on behalf of the
governed by special rules. School appointed a teacher. The teacher's approval of appointment was withheld for more than 4 years by the DI. But ultimately, the approval was approved by the principal secretary. And again, the areas were withheld by the DI. Then this honorable court, the London single judge, directed that yes, pay the area and recover the dues, the penal interest from his salary. Against that, this appeal has been preferred.
Against whose salary?
DI.
Against the DI.
DI is the appellant.
DI is the appellant here.
4
State
DI
is supporting.
served. 4 DI served during the tenure. I was made a party. First day, my lord, motion stays this order.
That I will be demonstrating, my lord, because the fact-finding authority says that he is the guilty person. The principal secretary is the appointing authority, and your lordship knows the special. So, for the special rules are concerned, principal secretary is the appropriate authority. He has held that is unchallenged.
whether area has been given.
Yes,
Area given, interest given. I have retired from
interest has
service.
also been paid. The interest has been taken from his salary.
No, interest has not been taken from my salary. State has paid.
Has also been
Yes.
paid, but
Got the
it has
interest.
not-
Yes, got the interest.
It has not been deducted from the appellants, my lord.
So now
The appeal is pending. Yes, that point is.
The state is also not interested.
you are not interested to recover
But,
the money.
such instruction is not there. They are
Order of
not-
principal
they have
secretary is
chosen
staring
not
at their
to file
face.
the affidavit. They have given some instruction, written instruction, my lord.
Kindly hear the matter, my lord. On
What
10th Feb,
principal secretary has said?
principal secretary has
Principal secretary
held.
earlier,
That getting recovery
earlier
from
made
the
some
salary
report
of-
and
Principal
instruction.
secretary issued shows against the DI.
And
Following that, my lord, the
DI
learned single judge directed that it should be recovered from his salary.
But to be honest,
The penal interest.
laches and negligence on part of this appellant is apparent on the face of the records, and the state is not
No,
denying
you
state.
say if your DI says that, if your principal secretary says that no, not required, we will finish it up. You will not comply with court's order, and at the same time you will not oppose an appeal filed by the DI.
Well, I
You
shall talk
cannot
to
take two
I shall talk
different
to the
stands.
DI and the state authority.
If you are so sympathetic and you want the only certain mistakes, if that is your claim, we will record that.
My lord.
But you should not be embarrassed because you are also speaking on behalf of the principal. So
That is
take
under
instruction
point of
from principal
consideration, my
secretary
lord.
that, sir, are we serious about this or it is only paper tiger?
My lord, may I talk to the DI and the other authorities?
Yes, you should certainly
But
talk.
they are
because,
secretary, whether state is still interested to recover the amount from the appellant or not.
your DI will not say. Your
lord.
principal secretary will say.
My
Here,
My
madam,
lord,
the
that
DI will, madam, DI, he has already retired, and this appeal has been filed in his personal capacity, not as a DI.
Right.
So,
He
madam,
will take from the principal secretary this thing.
My lord, I shall ask you.
You are for whom?
I'm for the state in 18.
In another matter,
State
the other
need.
matter. And I am in 19, my lord.
Yes, you should come with that instruction and dispose of the appeal. Yes.
Deeply obliged.
What is the amount of interest?
That not right now I am unable to say, my lord.
Now, whether DI was made a party personally with name.
Lord, there were 4 TIs. I tell your lordship.
The motion
I tell your lordship, Lord, there were 4 TIs who served during the tenure. I was made party by name and I was not in office.
My lord, that
I
contention
demitted office, joined another place.
My lord, this is not justified that the other DIs they have also been implicated in this appeal. This is not justified, my lord. I will show from the records that they cannot be implicated in this case.
I served for a limited period. I was made party by name. By that time, I had demitted office, joined elsewhere. And on the first day, my lord, this order was passed.
Such denial and laches that happened during the tenure of this DI, this appellant.
তুমি কনসিডার করো এখন আমরা অ্যাপিল করতে তো ওই এক লাইন দিয়ে বললে হবে না প্রিন্সিপাল ওই অর্ডারটা না থাকতে একটা কথা ছিল
State is not interested to recover.
Yes.
But 20, my lord, I appear for the writ petitioner respondent.
Who is the appellant?
I'm appealing for the district.
Here for the?
We are for the appellant university. And there were directions for filing of report. Reports have been exchanged, my lord. Your
My lord, further your lordship directed me to file an exception. We have already filed our exception.
Well, in an exception, he has make out a new case. That is why my lord asking for certain time for filing an
My
evidence.
lord, I have relied on three orders.
Upon a candidate for Niladri Vishwas.
Exception was filed.
Yes.
Exception was filed, but there they have brought in a new fact, my lord, about Niladri Vishwas, who was also
New fact in what?
About a person.
In what they have in the exception, in the affidavit, they have to that you have used an exception.
Affidavit filed by the state, my lord. Report filed by the state, they have used an exception.
Then what more exception you want to file?
Lordship, because they have brought out a new
Who has brought out?
By the writ petitioner respondent, my lord.
That was there in the report. So you did.
Was not in the report.
Then
report was filed by the state respondents. What happened, my lord? Initially, an officer was appointed. A person was appointed in officer post, my lord. Thereafter, he was designated into a teaching post without the concurrence of the state government that has been done by the university. When the wrong was detected, it was kept in a bag, and everything was sent before the state government. Thereafter, the petitioner filed a writ petition challenging that kept in abeyance order. And thereafter, now, my lord, your lordship, after hearing the this appeal, my lord, directed the state to file a report. They have filed it. And the petitioner has also used an exception, my lord.
petitioner means.
But we have.
Oh, you want to now use an exception.
But this was the submission on the last occasion. Your lordship directed me, lord, let them submit, my lord. If required, my lord, they will come up with an affidavit.
Kindly directs us to file an affidavit.
Now, what happened, my lord? We relied on, my lord, we relied on 3 orders. 3 orders of this honorable court,
where my learned friend was appearing for the university. The orders were passed in their presence. Now, my lord, they want to file another exception to this.
But that was in another case, my
No exception to the states.
No, my lord, they are not saying that. They are saying that exception to the exception filed by us.
affidavit to the exception. We just
They are trying
Oh,
to
they are one to the reply to the exception which you have filed.
file. My lord, we have relied on three orders of this honorable court and one order of the honorable Supreme Court, my lord, which has been passed by this honorable court. My lord, the appeal has been, SLP has been carried to the honorable Supreme Court, SLP dismissed. Only modifying the interest portion. Everything has been held, my lord, kept, not modified. My lord, to that, my lord, they are
So what
praying.
exception you will file to that?
No, whether if petition responded, whether you have introduced any new fact.
Nothing.
Yes, that.
My lord, only, my lord, I am relying on a similar judgment, my lord, passed by this honorable court, coordinate bench of this honorable court.
No, further this way you cannot delay.
No, my lord.
So you make your argument. We are considering that whether you at all require any opportunity to give any further. Huh?
Let the instruction of the university be on record. Let be a direct statement.
What instruction? Petitioner has brought in a report.
Well,
Your allegation is they are taking new points.
they are taking the point.
So you argue that what instruction will you place? Whatever instruction you want to place, you bring it. If there is a new point, tell us, explain to us the report.
Let it be a direction from the court, my lord.
No. Either you or we dismiss your appeal.
You point out that this portion is new.
Point out which portion is new.
Yes, তুই শুরু করে বল দর্শক বুঝলে তখন দেবেন নিশ্চয়ই
On judgment, এই যে নীলাদ্রি বিশ্বাস চাই।
You are not ready in the matter. That is why you are taking this time. If you are not ready, you humbly say to the court, but don't take a ground which is not acceptable. Where is your senior? He was here, Mr. Chaudhary. Where has he gone?
He's before courtroom number 1. He's coming. He's coming.
He's coming. This is his instruction that I will file another reply. Not today. We will hear it on Tuesday.
Can it be on Wednesday?
Huh?
Can it be on Wednesday?
Very good. Wednesday, you have to explain to us that why report is required.
Fine,
we are not satisfied with what you are saying. And if you want to show us any document, ask your authorities to send you that document. We will consider.
I'll produce this, any document.
Next.
Mal.
Great.
Much obliged.
Yes, 21. You are for the?
I'm for the appellant.
Who is opposing you, Mr. Badi?
Mr. Ranjan Saha and Bhaskar Boisho for the state. তো এটা দিয়ে দাও না জমা হয়ে গেছে কি করবা না থাকলে
Minute order দিয়েছে return record. What did we direct, Mr. Badi?
Your Lordship directed to file a supplementary affidavit annexing the copy of the affidavit in opposition.
No. You paid for leave.
Yes.
You paid for leave, but it was affirmed but not submitted
I have
before
not.
that.
The affirmation was made by the council's advocate.
Oh.
He paid for it.
So direction was given. They were keeping it
Yes.
without making. We require both the parties to have an instruction whether affidavit in opposition was made part of the record by the single judge.
Yes, one of the supplementary affidavit was directed to be affirmed. That's why I have affirmed.
No, you have not affirmed.
That's what?
Supplementary direction was upon Mr. Saha.
No, Mr. Bari, press for
আমাদের দিয়েছি তো।
Oh, yes, you prayed for it.
I have.
Where is your supplementary?
Supplementary affidavit we have kept on record.
Yes.
But we ask both of you to take instruction. On that date, Mr. Saha says, although it was affirmed,
it was not,
but it was not placed before the court. And that affidavit has not been made part of the record.
Yes.
That means court didn't consider this affidavit.
Unless
So since single bench did not consider whether we shall be able to consider or not, it is a question.
I have been served with the copy of the affidavit, but whether it was deposited or to the part of the record, I can't say.
You show any of the order that this affidavit is taken on record or kept with the record.
No, that is not there. That is not
So
there.
that is not part on the record. Part
Well,
of
that
the
is that. Well, it is the duty of the advocate to deposit the same before the
You want to use some or rely upon certain averment made in the said affidavit by the state. So you have to ascertain whether this affidavit was made part of the record or not.
That matter the. Let the record be called for then.
Otherwise, if this thing has not been considered
No,
by,
I follow you, Lord.
by the learned single judge, how we can consider?
Let the record be called for then. Like I am not in a position to, my lord, submit anything beyond the records.
Your junior will take out all the orders.
No, in the order it is not been reflected.
So it has not been made part of the record.
Yes. Whether it was deposited or not.
So let it kept on the record, but you don't rely upon.
Very well.
You stand, place your case, keeping that there is no such supplementary affidavit.
Keep it. Next day, Mr. Boisho is not here. The state is the main.
No, the date. 2nd February, 3rd February রেখে দাও।
হবে আমরা আছিস না ফরেস্ট কেমন আমাদের for the appellant, your lordship. There is a delay, your lordship, of 11 days. I've served your lordship with the affidavit of service in terms of the law.
Who is your other side?
I've just served your lordship this affidavit of service in terms of the last election.
Nine days.
What is the main matter about?
Lordship, I had gotten higher skill.
Just যেটা বন্ধন করে এবিডি
In your lordship.
This is a dismissal of a review petition.
Lordship.
No, no, ওটা বলেছে
No,
যে
your lordship.
6 review or
This is the order
September
dated
20
August
reconsideration of the
26, 2022. With the memo, lordship. Impugned order.
2012 when did you retire?
I retired during the pendency, your lordship, during the
Oh.
pendency.
কিছুই দেখে আসুন
You bring the writ petition, at least writ petition, we shall be able to look such a document when you retired, when the order.
unnecessary matters are pending. See, unnecessarily it is pending. You could have filed an application for appropriate order.
He is suffering, that is why he could not come. If some time could be given, I'll file the application.
How long, sir?
2 weeks
From
time.
September it is being
2
done.
weeks time, your lordship. I'm appearing for the first time, your lordship, in this matter, your lordship. 2 weeks time, your lordship gives me.
10th February. No, that we are sending it out of list. You file an application and bench.
Yes, sir.
Section 5 টা allow করবে না? 11 দিন আছে।
11 days delay.
Orderটা।
Acha, yes. Affidavit of service filed on behalf of the applicant is taken on record. Stop.
Body.
Well, I put the writ petition and responded.
Order 23, my lord, the appeal, my lord, filed by my lord, the Director of School Education, as well as my lord, the State of West Bengal.
Reply file.
Now, my lord, there is a section 5 application also, 400 and odd, my lord, the delay.
You have
400 and
filed the, you don't want to file the reply, Mr. Sen?
my lord, the opposition, no.
Opposition you have filed.
Opposition to section 5, but reply not yet filed. So, my lord, yes, my lord, I shall.
You don't want to file the reply.
I want to file.
My lord, that is the difficulty we are facing. 1995, 2014, the order. Matter was once dismissed for default. Restoration, no opposition. I have given no objection to filing the restoration application.
But
My lord, contempt is petition.
May I tell lordship? My lord, the section 5 application, my lord knows that, my lord, I have, my lord, the stated some facts. Why this 468 days delay? Now, my lord, it is entirely, my lord, up to the court with regard to the satisfaction of. Now, my lord, if I satisfy your lordship with regard to that explanation, then I think, my lord, there is no question of, my lord, that
Yes.
Now, my lord, if you, now, my lord, may I tell just a minute, my lord, with regard to the 5 minutes, my lord, the fact. My lord, the fact is that, বসো না তুমি তুমি একসাথে দুজনে বলবো না নিশ্চয়ই। Now, my lord, the fact is that, my lord, one writ petition was filed whereby the petitioner prays for, my lord, the permanent approval of his status as a, my lord, the organizing assistant teacher in a particular school up for class 7, 8. Now, my lord, may I tell? That, my lord, the writ petition was disposed of, directing the, my lord, the director of school education to, my lord, consider his claim or his prayer. Now, my lord, that was rejected on the ground that there is no provision under the law with regard to, my lord, the appointment or engagement of any such organizing teacher, number one. Number two, there was no vacancy in that particular school. Number three, the school already established before his, my lord, that engagement letter. So on all these grounds, my lord, rejected. Then, my lord, the second writ petition filed. In that writ petition, this impugned order was, my lord, passed, whereby, my lord, the order of the director of school education, my lord, after having been setting aside, then, my lord, directed to, my lord, to approve the same. Though he now retired, now we have preferred an appeal against this. Now, my lord, this, my lord, the no doubt, my lord, that there is some delay, my lord, 468 days delay. My lord, we have, my lord, this is not, and my lord, we have tried to excuse, not excuse, but explanation. It has been given here.
Show us,
my lord. Lordship, kindly come to, my lord, the paragraph number 3 onwards.
Yes, just.
My lord.
So, Mr. Sen, it is a direction that he has admittedly, fact remains, he has now retired. So the court said that you treat him as an organizing staff and approve it at least so that he can get pension. That is the order. That is the order. So you will, when you are there, you certainly will advise them that you comply with this and let him enjoy pension. Now, after the judgment of the
pension and other retirement benefits, keeping in mind that the petitioner had approached the court for the first time in 1995.
When did you attain 60 years?
When the order has passed. Before that.
Before that, order was passed 2014.
My lord.
My
lord, I have, that is recorded in the order itself. Yeah, I have already retired.
কবে রিটায়ার? 14 থেকে 26 বছর, 10 বছর হয়ে গেছে।
103
10 বছরের এরিয়া পেনশন, তাহলে যদি না দেয়
pensionary benefit.
pension. So the pension, if it is given, you become entitled to the pension from the date of your retirement.
Kindly come to 103. Judge was learned single judge is very conscious about that fact that I am on the view that petitioner's appointment should be approved as an organizing staff. Mr. So informed the petitioner has already reached the age of superannuation. My lord, page 103 from the last. from the last portion of the order. 103 of the stay application. My lord, kindly see the second last paragraph. My lord, got it?
Second last.
103. My lord, I am on the view. My lord, specific submission of the petitioner regarding the vacancy position of the school remains uncontroverted. In such of the view, the order impugns such and such is set aside. I am of the view that the petitioner's appointment should be approved as an organizing staff. Mr. So-and-so informed the petitioner has already reached the age of superannuation and already retired.
We are wanting to know, Mr. Das, today. So, what will be your entitlement? How much will you get?
Well, court is totally left this entire fact on the authority. Whatever after the calculation, what will be the retrial that then, my lord, next paragraph. In such view, respondent number 2 is directed to approve the appointment of the petitioner as an organizing staff from a date that after the retirement at least can get the pensionary benefit of the pension and other retirement benefits.
So at least you can get pensionary benefit. So pensionary benefit, your entitlement flow from the date of your retirement.
My lord can record it. I have on that portion. My lord can get it as a notional by the order of this court.
This is a very good suggestion, Mr. Sen.
No, my lord, but my lord, our
Suppose today we dismiss your section 5, you have to go to Supreme Court, whatever it may be deemed. But you have to shift the burden. But by that time, this person will die.
How can I argue, mother, at gunpoint?
No. I am not. We are not pointing a gun. We are wanting to have a bullet on our own.
No,
You are the additional advocate general. We have seen you to be extremely reasonable. We have found you to be helpful to the court. So,
my lord, the question is, lordship, kindly consider one thing. The question is, my lord, not that is, my lord, the single matter, or there may not be other, my lord, this type of matter. Because of the fact, may I tell before lordship, on earlier occasion, my lord, at least there are 3 division bench judgment of this court, where, my lord, the similar matters, where, my lord, the persons who filed the writ petition claiming for approval of organizing teacher as their assistant teacher, all, my lord, the rejected, and the division bench in 3 matters. The division bench said that no, there is no provision for organizing teacher, and more so after, my lord, in 1997, when School Service Commission, my lord, that is act came into effect.
No, that is on merit, Mr. Sen.
On
But
merit.
how do you overcome the
And
barrier?
in one of from the order of this court, my lord, the writ petitioner therein, who, my lord, failed before the division bench, they went before the Supreme
That
Court.
was also
And
dismissed.
that was also rejected, and rejected not in such an in limine, but rejected after observing that we gone through the papers, we gone through the records, and it appears to us our finding not to interfere in this matter.
Then you place your section 5, Mr. Sen, because merits we will take up later. Yes. Section 5 is yes.
And my lord, I know, my lord, sometimes it is very difficult, my lord, even to satisfy, my lord, 468 days delay. And but all depends upon, my lord, may I tell one
By
thing?
the facts and circumstances.
Yes, lordship.
Yes.
And also, my lord, kindly consider one thing, my lord, normally, my lord, it is seen that whenever the section 5 application is being taken up, my lords are kind enough to also ask the council that what about the facts of the matter in merit also, so that if there is something that
Merit, Mr. Sen, this matter we merits we are not going now. When we were hearing the matter, the recent Supreme Court judgment was also placed before us. Now it is becoming extremely difficult to condone huge delay.
My lord,
State has to bring up some modality how to.
in that matter, so far I, my lord, recall
Okay, please, Mr.
huge delay.
Then, Mr. Sen, let us go
Practically
into the merits and finish it off.
More than 4 or 5 years delay in that matter. 11 years delay.
Yes. What is your explanation given, Mr.
My lord, they paragraph 3 onwards, lordship. Judgment.
According to you, delay is only of 468 days.
468.
But the delay is 4,500 and something. How much is the delay? Oh, 460. Four 38. Advocated fine misplaced.
Want to place, my lord. I know, my lord, that that judgment cannot, my lord, may not satisfy your lordship, but I rely upon one judgment of the Honorable Supreme Court. With regard to this, my lord, the explanation and satisfaction, because these are correlated, explanation and
Dotto's
satisfaction.
judgment.
My lord, that is my 2023 10 SCC, Shivraj Singh. Shivraj Singh. If your lordship kindly have a look, my lord, just 3 or 4 paragraphs. I know, my lord.
It should be an explanation, not an excuse.
Yes, yes, yes. Now, my lord, now, my lord, kindly. I'm grateful to your lordship. Now, paragraph 26 onwards, only 2 or 3 paragraphs, lordship, kindly have a look.
This has been discussed in that Justice Padriwala's
Yes, discussed. I know it. Discussed. And there it was 11 years delay, I think, in that matter. Lordship, kindly come to my lord for my satisfaction, my lord, paragraph 26 first, lordship. Have you also got him, paragraph 26. G. Ramagowada versus LAO, while summarizing the position of law on sufficient cause, had the occasion to observe that the contours of the area of discretion of the courts in the matter of condonation of delay in filing appeals have been set out in a number of pronouncements of this court. It was observed to be true that there is no general principle saving the party from all mistakes of its counsel. Noting that there is no reason, because it is also there is a mistake of the counsel, I have made it. Noting that there is no reason why the opposite side should be exposed to a time-barred appeal if there was negligence, deliberate or gross inaction or lack of bona fides on the part of the party, or it is the counsel. It was further observed that each case will have to be considered on the particularities of its own special facts. However, this court reiterated that the expression sufficient cause in section 5 must receive a liberal construction so as to advance substantial justice, and generally delays in preparing appeals are required to be condoned in the interest of justice where no gross negligence or deliberate inaction or lack of bona fide is imputable to the party seeking condonation of the delay. This was followed in these words: in litigations to which government is a party, there is yet another aspect which perhaps cannot be ignored. If appeals brought by government are lost for such defaults, no person is individually affected, but what in the ultimate analysis suffers is public interest. The decisions of government are collective and institutional decisions and do not share the characteristics of decisions of private individuals. Therefore, in assessing what in a particular case constitutes sufficient cause for purposes of section 5, it might perhaps be somewhat unrealistic to exclude from the considerations that go into the judicial verdict these factors which are peculiar to and characteristic of the functioning of the government. Governmental decisions are proverbially slow or encumbered as they are by a considerable degree of procedural red tape in the process of their making. A certain amount of latitude is therefore not impermissible. It is rightly said that those who those who bear responsibility of government must have a little play at the points. Due to recognition of these limitations on governmental functioning, of course within reasonable limits, is necessary if the judicial approach is not to be rendered unrealistic. It would perhaps be unfair and unrealistic to put government and private parties on the same footing in all respects in such matters. Implicit in the very nature of governmental functioning in procedural delay, incidental to the decision-making process. Now, my lord, the rest of the 2 or 3 paragraphs also on that line. Now, my lord, my humble submission is this, and if there are, my lord, the other judgment also, but if we go back to, my lord, the at least 30 years back in 1996 also, if your lordship, my lord, kindly have a look at them. And I rely upon 1996 volume 3 SCC, page 132. 132. But it was a 3 judges bench decision, and my lord, kindly come to only paragraph number 11. Just for a 3 judges bench decision, paragraph number 11. Well, may I read out paragraph 11? It is notorious and common knowledge that delay in more than 60% of the cases filed in this court. Para 9. Para 11. Be it by private party or the state, are barred by limitation, and this court generally adopts liberal approach in condonation of delay, finding somewhat sufficient cause to decide the appeal on merits. It is equally common knowledge that litigant, including the state, are accorded the same treatment, and the law is administered in an even-handed manner. When the state is an applicant praying for condonation of delay, it is common knowledge that on account of impersonal machinery and the inherited bureaucratic methodology imbued with the note-making, file-pushing, and passing on the buck ethos, delay on the part of the state is less difficult to understand, though more difficult to approve. But the state represents collective cause of community. It is axiomatic that decisions are taken by officers, agencies proverbially at slow pace, an encumbered process of pushing the file from table to table and keeping it on table for considerable time, causing delay. intentional or otherwise, is a routine. Considerable delay of procedural red tape in the process of their making decision is a common feature. Therefore, certain amount of latitude is not impermissible. If the appeals brought by the state are lost for such default, no person is individually affected, but what in the ultimate analysis suffers is public interest. The expression sufficient cost should therefore be considered with pragmatism in justice-oriented approach rather than the technical detection of sufficient cost for explaining every day's delay. The factors which are peculiar to and characteristic of the functioning of the government conditions would be cognizant to and requires adoption of pragmatic approach in justice-oriented process. The court should decide the matters on merits unless the case is hopelessly without merit. No separate standards to determine the cost laid by the state vis-a-vis private litigant could be laid to prove strict standards of sufficient cause. The government is at appropriate level should constitute legal cell to examine the cases when any legal principles are involved for decision by the courts or whether cases require adjustment and should authorize the officers to take a decision or give appropriate permission for settlement. In the event of decision of file appeal needed, prompt action should be pursued by the officer responsible to file the appeal and he should be made personally responsible for lapses, if any. Equally, the state cannot be put on the same footing as an individual. The individual would always be quick in taking the decision whether he would pursue the remedy by way of an appeal or application, since he is a person legally injured, while state is an impersonal machinery working through its officers or servants. Considered from this perspective, it must be held that a delay of 109 days of this case has been explained and that it is a fit case for condonation of delay. So, my lord, my humble submission is this, that, my lord, that we admit this is a fact, there are delays, but, my lord, we have, my lord, but this is not a case that we have tried our best level to explain. No, this is no question of tried our best level. This is a question that the facts we placed. Kindly consider. Sometimes, my lord, we say that this is our, my lord, we have tried our level best. No, I have never argued I tried our level best. No, this is the facts what we, my lord, enumerated in my lord, section 5 application. These are the facts that what prevented us from filing or preparing the appeal within time. But, my lord, I think, my lord, we think the state, my client think that, my lord, there is a, my lord, the sufficient, my lord, the grounds to prepare the appeal. So, my lord, I beseech your lordship, my lord, kindly condone the delay and hear the appeal any day, any time. I would not take much time.
Yes, Mr. Anything else, Mr.
No. And, my lord, so far the opposition is concerned, I think, my lord, the facts I have pleaded, so, my lord, no question of opposition.
My learned senior friend has already placed the section 5 application before your lordship, and my learned senior friend has relied upon the two judgment of the Honorable Supreme Court, Apex Court. But unfortunately, those cases has already been considered by latest judgment of and paragraph dealt with, and the grounds taken has been not been.
Show us that. What is your first opposition? Take us to your opposition.
My lord, in opposition, we have taken 2 points. Preliminary 2 points. Number one, they have stated the facts A to B, B to C, C to D, but they have not annexed anything with their merest statement. And second point is more than 200 days delay has been shifted to the grounds of such a senior advocate of this honorable court. This is not expected from the department. And this practice has been deprecated by the Honorable Supreme Court and as well as the recent judgment of our court, that burden cannot be shifted from any advocate's ground. And my lord, if I go beyond that, my lord, the statement made is absolutely not at all be satisfactory, and my lord, 200 days when the original paper certified for copies has been lost.
Show us those points.
Fine.
To us.
My lord, kindly come to page 5 of the application. First.
Page 5.
Page 5 of
Yes.
My lord, on 7/27/3/14, the Joint Director of School Education 1 instructed the concerned dealing officer to make a prayer of certified copy on order of the learned legal remembrance, West Bengal. Prayer obtaining certified copy of the order was made before the learned legal remembrance on my lord
28th March 2020.
My lord, kindly marks the date.
No, order was passed on.
Order was passed on my lord
17th January 2014.
17 January 2014.
17 January 2014. So they say first thing in paragraph 3. That was an expertise order.
Expertise order.
So they received the communication on 21st of March 2014.
Immediately thereafter, my lord, 27th.
Yes, 27th they went to the director.
Director. And then my lord, requisition has been made for obtaining
certified
copy of 28/3/2014.
That is after 1 day.
1 day.
Hmm.
No document has been annexed. Nothing. That statement from to my knowledge. Thereafter, my lord,
17th April.
17 April.
2014 till
21st. My lord, kindly only mark the date, not explanation.
Then 25th.
20th.
Then 7th May.
Then 13th.
Very good.
Thereafter, my lord, 16th. Then, my lord, 6/6/2014.
No, 16. Then 26th May.
26th May, legal remembrance approved the proposal of appeal. All are the statements. My lord, thereafter, my lord,
6/6. Then 9/6.
9/6.
Then 23rd June.
My lord, then no explanation.
Then 13th November received.
Yes. My lord, that 6 months, no explanation.
Now given on 20th of November to Mr. Chattopadhyay. 20th November 2014, it was misplaced.
No, my lord. Then, my lord, the appeal, the list of dates handed over on 18/1/2015. 28/1/2015. My lord, last page of last line of the
28/1/2015.
Then, my lord, no explanation. Copy missing.
When was ultimately filed? 30th April.
30 April 2000.
So, in fact, the file was missing for 3 months.
3 months.
3 months, not
No.
28th January 2025, the list of dates was given. If we take that, prior to that 13th November 2014, the certified copy was received.
Certified copy application to cover.
Entirely, my lord. Day before
over.
yesterday, your lordship has passed that order, my lord, in MAT 848 of 2015. Lordship has indicated that the application of certified copy and ultimately certified copy, two dates are different.
Here also 2 dates.
No, application made. Thereafter obtained. My lord, that judgment is not over yet. Correction.
Very good. So what is your statement?
My lord, my statement is that this is a completely an statement for explanation. No document is annexed to that effect. My lord, so far my knowledge goes, there should be a lay note or any document is there to substantiate these dates. Who will verifying this date? Whether at all being done? at least any official. That's why, my lord, they are not. We have taken all the points in the opposition, and they have not used the reply.
Show us where is the opposition you have stated that no documenting support was there.
My lord, page 4. Page 4.
Yes.
My lord, last paragraph. Sorry, before 7th, it is not out of place to mention that the applicant has not annexed a single document to substantiate that timeline of event and the internal movement and communications or file progress or relies upon any bare and such unsupported statement cannot be constitute a sufficient cause, and the date mentioned and application are unsupported by any documentary evidence, and the statement is mere assertion made out of true to my knowledge in any affidavit and from the responsible officer or the protecting official, and section 5 be allowed to bear statement.
Yes.
And my lord, especially my lord, paragraph number 6 of my page 3.
What you have placed is also part of para 6.
3 months blame blame has been shifted to an advocate.
3 months? Why you have
more than 3 months?
Why you have written 6 months?
Prior to that, handed over, then list of dates that was given, then my lord, lost of document of 3 months. That time has not been explained. Unexplained delay of 6 months.
28 January 2015.
No, my lord, before that,
13th November 2014, the
my lord, 20
number they received the on 20.
My lord, Mr. Chattopadhyay has received the
handed over on 23rd June.
No, my lord, 11/2014.
No. Page 6.
Page 6, my lord, in the original certified copy of the order was handed over the clerk of Mr. So and so advocate on 20th 11 2014. From 20th 11 2014 till my lord 30th April 2015 is more than 6 and that has shift, the whole burden has shifted to learned advocate. My lord, first I rely upon the judgment of
Brahma.
that is 25 Life Law SC 899. Not other than my lord handed.
You handed over.
My lord, right? 25 Life Law bracket SC page 889. 899. My lord, in this particular.
Didn't we return it back to you? তাহলে জাজমেন্টটা গেল কোথায়? এই ম্যাটারে সেটা তো একটা ফ্রেশ কপি প্লেস করেছিল, সেটার একটা কপি আমরা রেখেছিলাম। এটা তো অন্য অ্যাপিল। এইখানে
যেটা দিয়েছিল সেটা কালকে ফেরত দিয়ে দিয়েছি।
On earlier occasion when the matter was taken up, I have handed over 2 sets of.
তাহলে ওই কপিগুলো কোথায় গেল? কোন ফাইলে?
আমাদের চেম্বারে গিয়ে দিয়ে এসছে, ওইখানে পড়ে আছে ওটা কি?
এটাতে বলছে paragraphs we will take note.
My lord, 176 of the judgment.
Huh.
My lord, firstly, I say the background of this judgment. My lord, when I gone through the entire judgment, I found that this judgment of based upon the two arena of Section 5. One arena has been Postmaster General prior to Postmaster General and after the Postmaster General judgment of the Honorable Supreme Court. And Justice Padliwala has consciously taken care of that court should take a liberal view. That was the explanation and that was the view altogether in various high courts and the Supreme Courts regarding while dealing upon the Section 5 application of the state respondent. And my lord, various judgment was there, and my learned senior friend has also relied upon those judgment that was also considered in that. And after Postmaster General, the Supreme Court has take a different view, and day-to-day explanation is required. And as to why that even there is a, my lord, the Supreme Court go to that extent, even there is a 1 day delay.
This is a two judges bench. Your
Division
Justice
Patliwala. Justice
Division.
Patliwala. And my lord, paragraph number 176.
Judgment cited by Mr. Sen is of a three judges bench.
My lord, that was also considered.
You should tell us which.
My lord, 176.
176.
6 of that paragraph 176.
Hmm. In Mr. Das, in Postmaster General, the proposition was what? This concept of public interest, that the state cannot be made to suffer for the laches on the part of the employee concerned, red tapeism. On the basis of this, some amount of flexibility has to be given to the state. So that issue, which paragraph has been dealt?
My lord, firstly,
because the flexibility, even if granted, that does not satisfy the explanation given. Suppose a private individual can file an appeal, even after obtaining certificate within the very next day, appeal can be filed. But in the government mechanism, that is not the procedure.
My lord, kindly consider page 2, point number C and D.
Page 2 of
the judgment I have handed over.
Page 1, para 176.
No, firstly, my lord, page 2, point number C and D is indicated in the point number C is dealt with in what circumstances can exercise of discretion to condonation of delay be interfered with. My lord, that portion of the Supreme Court has dealt with. And my lord, D is there is no room for largesses for the state lethargy and ensure under Section 5 of the Limitation Act. And my lord, the reported person. My lord, page 176 of the judgment, paragraph 176.
You, according to your reading, what does the court say?
My lord,
you first give us the paragraphs. 176.
176 were dealt with the relied upon judgment of my honorable.
Which other paragraph?
And my lord, the Surjo Dev is also considered in paragraph number 221, 220 and 221.
Very good. Any other paragraph you want to return?
Well, there are several paragraphs which dealt with the Section 5, and it is I called it a compendium of Section 5 judgments. My lord,
Section 3 and Section
5.
It went to the extent of saying that 30 days period for filing mandamus appeal, that is also not. The earlier view was that 30 days no explanation is required, because that is the time given for filing appeal.
If it is the 31 days, then you have to give a total 30 days.
Because Section 3 is mandatory. This is the way. Achha, very good.
My lord, important paragraphs are 207,
207,
208, 212, 213, 228, The sorry, my lord, 218, 219, 220, 221.
228 to
my lord, 218, 219, 220, 221. Entire concept.
Yes.
No.
পেয়েছো?
That is the unreported one. The paragraphs are will not be tallied.
কোত্থেকে বের করি? This is your
And my lord, penultimately, my lord, 228 to 235, discussing under the conclusion portion, where it is stated that no delay can be condoned if it is not be sufficiently well claused and given sufficient cause. And my lord, the judgment of Surjo Dev and the other judgment of my learned senior friend has been considered. And ultimately, my lord, conclusion has been taken 261 to 268. And my lord, I am relied upon a judgment of
yes,
Justice Padliwala in another judgment. It is also in 2024. In 2024 Supreme SC Supreme 110101.
ও এসে গেছে যাচ্ছে
Cannot be shipped upon the learned advocate. It
Para?
is, my lord, paragraph is para 10, 12 and 13. And my lord, rely upon that, my lord, the Honorable Justice Bhattacharya of this Honorable Court has passed an order dismissing the Section 5 only 268 days. But entire blame upon the advocate in that case. It cannot be. And my lord, lastly, my lord, I rely upon the judgment and order of their unreported judgment of Honorable Justice Harry Standen and Honorable Justice Chatterjee regarding explanation of Section 5. And my lord, I shall also
please give the citations.
and I also relied upon the unreported judgment with a judgment your lordship has passed in MAT number a day before yesterday. That has not been. My lord, that is MAT 848.
It has already been served. When we have served.
I have been.
It is served হয়ে গেছে কাল।
My lord, order dated say explanation of Section 5 and state should not be armed with an preferred litigant. বলে দিচ্ছে। And my lord, if it is সব দিয়ে দেবো, sir. But even we go even we got the merit of the case, that case is also covered by the Honorable Supreme Court in the recent judgment of my lord Vikram Nath in Jaggoan. If you utilize my service and the learned on the last occasion, my learned
That
senior
is on the merit.
that is on the merit. Even in on the merit, I am entitled. Well, I can satisfy.
Then we are keeping it as for orders. We'll pass a order.
My lord, the should unreported judgment be.
Yes, I am handing over all the judgments. I am handing over all the judgments.
We have extensively heard.
Only thing that, my lord, that
one request to 27, item 27. It may be expected to take up on Monday. Kindly, if I don't remember, kindly take it up.
Monday, you
Oh,
are coming.
then it's all right. 13th I will be there. Sorry, I have this. Got
Fixed at 2 p.m. as for daughters. Yes, Mr.
No, it's all right. Tuesday it will be taken up, no problem.
Yeah.
No problem.
20th.
Mr. Sen.
Mr. Sen, 20th.
20. We have kept it at 2 p.m. If want to say in any word on that.
Actually, 12 in Supreme Court is working day. That's the reason it was kept in my mind working day. Sorry.
My lord, in person, my lord.
in person কি চাচা ছিল in person যে বলছিল
মাইলট আমার 32 নম্বরে ছিল মাইলট, ওটা মঙ্গলবার দিন মাইলট একটু আগে দিকে করা অনুরোধ করছি, মানে মালদা থেকে আসছি না মাইলট।
একটু শুনতে হবে
Item number one.
you have finished now.
Yes, my lord was only being requesting of delivery of judgment only for that. Everything was fine.
Yes. The learned.
What happened, in the meantime, one of the appellants, Sadhana Shaha, number 3 died. We prepared, we have prepared the application for substitution within time, 26 December 2025 died. Now, my lord, yesterday, my lord, the Sadhu ceremony was happening, my lord. That's why, my lord, I could not affirm this application, but my lord, ready. Let the matter will appear any day open, your lordship. Just, my lord,
But if substitution is not made, everything will become difficult. Huh?
This is Sadhana Shaha, 26 December, my lord, appellate number 3.
এই যেদিনকে সোনালী খাতুন মামলাটা ফিক্স করা আছে কন্টেম্পটেড have to file the application, give a copy, na? Otherwise, how can we?
Yes, my lord, because my lord, not it upon, that's why it's a problem.
Then we are, Mr. Rai, you give a copy to him. We are keeping it on. কবে আজকে এই মাসের শেষে এটা তো 5 মিনিটের জন্য we'll keep it Friday, 30th. We will allow subject to
Yes,
hearing.
sir.
We will allow and reserve the judgment and deliver the judgment. Otherwise, again, it will take time.
Because it has not been made CAB. So if it is that, because recording parts to CAB, my lord,
You
everything.
cannot record CAB, na?
Yes, that is why, my lord.
You cannot, how early can you file?
Next week, any day. Next week, any day. Wednesday.
22 তারিখে আসবো। দরকার নেই। All right, 30th at 3:25.
Only one thing, my lord, I am praying before your lordship, my lord. During the after passing of this, judgment, my lord, there is something is going on in the locality and also the plots are being concerned. Though injunction application was filed, my lord, only one thing, if something we protection might be
At this stage?
At this stage, that are also because our impressions. I'm not inviting a lordship to pass any mandatory order or injunction.
যখন রেডি হয়ে গেছে ইয়ে করে লাভ নেই। ও কবে ফাইল করতে হবে সেটার উপর তো ডিপেন্ড করে। Then we are keeping it on 22nd.
As your lordship. Within the period of limitation, it can be
22nd, এই 22 তারিখ ওই কি বার পড়ছে?
বৃহস্পতিবার।
ওই বৃহস্পতিবার ওই
ডিম ফ্রাইডে 23 থেকে ছুটি। 22 তারিখে আমরা বসে ওটাকে সিএবি করে দেবো, যে 5 তারিখে যখন বসবো।
হ্যাঁ সেটা দিয়ে 22 তারিখে তাহলে কি ওই 3:30 আবার 22nd.
as your lordship. Grateful to your lordship.
At
3:25.
Sheila Didi.
ঠিক আছে।
আর কি আছে বলো ডাকো।
Grateful to your lordship.
Date করে দাও। This is কটা ম্যাটার আছে আজকে?
ব্যাস এই দুটোই। হবে না।
Your lordship, my lord, I just started arguing. My lord has directed me to give a comparative chart. My learned friend relied on judgment which was not relied on before the court below, trial court. My lord has directed me.
All right, on 6th, it will be there on 6th February. Please control.